All rise. The Court of Appeals Division 1 is now in session. Thank you. Please be seated. And welcome. This is Court of Appeals, South Point Energy Center versus Department of Revenue and Mojave County. Court of Appeals number CA-TX150005 and CA-TX150006. Welcome here. For your information, we are recording these proceedings. They are recorded, hopefully, if everything works correctly, both audially and visually, so you can each have your 20 minutes of fame on YouTube, if it works correctly. As you approach the bench, please give us your name and who you are representing. Each side will have 20 minutes. You may reserve a portion of your time for rebuttal. And if you'll tell us how much time you want, then we will know how much time to not horn into too much. So with that in mind, let's get started.
May it please the Court, my name is Ben Cooper and I represent South Point Energy Center. I would like to reserve 5 minutes for rebuttal, if possible. The tax court erred in dismissing South Point's action because the prior Calpine action, which was about Arizona tax exemptions for federally owned land as to earlier tax years, did not actually litigate, much less decide, federal preemption as to Indian lands. And it simply could not immunize the Department of Revenue's errors that are unrelated to the ownership issue or otherwise immunize illegal taxation in perpetuity. It's undisputed that Calpine, as South Point's predecessor in interest, did not actually litigate, and in fact affirmatively declined to raise federal preemption, as was its right. Under Arizona controlling law, actually litigated means properly raised by the pleadings or otherwise and submitted for determination. That's the Cheney building case. Calpine rested, as was its strategic option, solely on the ground of an Arizona constitutional and statutory exemption for property owned by the federal government, state government, county, or municipality. It did not raise any other issues. Now, as this case, on the other hand, does not raise ownership from Arizona law or any other law. Rather, it raises federal preemption regardless of ownership. To state the issues is to distinguish them. They are not identical, which Arizona has required under the Aldaba case, or precisely the same, the Supreme Court's formulation in the Jimenez case, because there are different legal standards that apply to them. Any doubt that that's the standard for issue preclusion was resolved by the U.S. Supreme Court in 2015 in the B&B hardware case, where the court cited the restatement second of judgments and said, we turn to the restatement for guidance, and this is the standard. And that's precisely the standard we had advocated.
You're not asking us to decide the preemption issue in this appeal, correct?
That's correct. We discussed this heavy discussion of preemption because of the exceptions to preclusion, even if the issues are identical. We submit that the court doesn't even have to reach those exceptions because the issues are not identical to
you don't really want to argue that there's a change in the law here, because if one is to believe the Ninth Circuit, this law has been obvious since 1973.
That's correct. We believe that there has been significant clarification of what the law has always been. We do not argue that the law has changed, nor do we for purposes of the restatement exception. A clarification is enough. But in any event, the court doesn't even have to reach the exception because the issues are simply not the same. There are no cases that we have been able to find, and certainly that either the tax court or the department is able to find, that treat the issue in a case as the legality or illegality or taxability of property. Because taxability or legality or illegality are the end results from the application of one or more legal standards. The question is, what are the legal standards and are they identical? The restatement illustrates this with a installment contract, where in the first action you're challenging one installment on the basis of statute of frauds, and the restatement says in a subsequent action, you can challenge other installments on any ground other than statute of frauds. Now, the two most applicable cases are the Second Circuit decision Green versus the United States and McLean Western versus Department of Revenue from Colorado Court of Appeals, because those cases both involve successive tax challenges and application of the restatement standards for issue preclusion. And both of those cases recognize that because every tax year is a new claim, as long as you're dealing with a successive tax year, you can raise a challenge that you didn't raise before because it's a different tax claim. Because if it had been the same tax year, we would be facing claim preclusion. But because these are much later tax years than were at issue in the Calpine case, there is no, the department has not raised a claim preclusion defense, so we're dealing with issue preclusion. At that point, all you ask is, were the standards, legal standards, the same? And I think the department never argues that it's the same legal standard for federal preemption in Arizona law. If you look at the Arizona analysis of whether you're owned by a governmental entity or the private taxpayer, you look at, as in the Calpine case, the language of the lease, the lack of rental obligations for improvements, the control over removal or replacement of improvements. That is, it's very much a traditional ownership analysis. In fact, the Arizona cases show it has nothing to do with Indian issues, because Fox Riverside Theater and Cutter Aviation didn't deal with Indian properties. Cutter Aviation was a hangar.
I apologize. Can I slow you down for a second? I just need to understand your argument a little bit better.
Certainly.
Okay. So you're analogizing this to a different tax code. So if the state legislature had gone in and changed the categories or the assessments, you would have been able to use a case that had been decided under a tax code that was in place 10 years earlier. I understand that. So the change in the tax code is what?
Well, there is no change in the material change in the tax code.
All right. So I guess I'm not following you.
Okay.
Why isn't there issue preclusion?
Because it's not the same issue. The first issue dealt with the challenge to the tax was based on the Arizona exemptions, constitutional and statutory, for government-owned land. And the argument was that because the federal government held the land in trust for the Indian tribes, it was exempt under Arizona law. That's not the issue in this case. No one is suggesting that South Point does not own the property and that the tribe does. The question in this case is, as to later tax years, regardless of ownership, who owns it, is the tax preempted not by Arizona law but by federal law?
I just don't see how you get around the preemption issue. It seems like you're kind of dancing around it.
I'm sorry.
I mean, is this a preemption case or not?
This is a preemption case.
Okay, so, I mean, I wrote down a minute ago, Judge Swan asked you, do we have to decide the preemption issue? And you said, no, we don't.
Well, the reason this court is not yet at the preemption stage is the tax court dismissed the claims not because of a ruling on the merits of preemption, but because the court held that issue preclusion applied, so it didn't even get to the merits. So what this court needs to do is...
On the preemption issue, though. I mean, that's the underlying distinction. That's what makes these cases not identical, according to your argument.
But we're not yet to the merits.
Bear with me. I mean, how do we get around the preemption issue? Don't we have to address that then to get to where you want us to go?
Ultimately, yes. But because that hasn't been teed up in the tax court and the parties might have more to say, the briefing gave the court a flavor of what will come. If the court reverses on the grounds the tax court relied on, then the preemption issues will be worked out in the tax court in the first instance, and then I imagine will come up on appeal. These are major issues of consequence.
If I understand your position correctly, you're telling us that if we conclude that this case is about preemption, that's enough to get you out of issue preclusion, and then you can litigate preemption in the tax court.
Thank you, Your Honor. That's exactly correct. We're just trying to get to a discussion of the merits of preemption. The tax court's argument was, well, you could have or might have raised preemption in the prior case, and therefore you're bound. Anytime you hear arguments about would have, could have, should have, you know you're not talking about issue preclusion anymore. because Arizona law under 4501 North Point and Air Freight Express is clear that arguments about what could have been raised in the prior action are irrelevant to issue preclusion. They are creatures of claim preclusion. The question is, was it actually litigated? And the prior case was not about preemption, it was about ownership. And therefore, both Green and McLean and the restatement acknowledge the propriety of bringing successive challenges on different grounds for different tax years. It's perfectly legitimate. One is allowed to make the strategic decision. That's particularly true in tax, which the restatement uses as an illustration of a context where the risk of inequitable administration of the laws makes collateral estoppel particularly inappropriate. Now, as we've said, we don't think the court needs to reach the exceptions, but it bears noting that the department's arguments about the exceptions bring in the merits of preemption. But because the tax court didn't get beyond preclusion to the merits, it shows the need to go back and litigate the merits of our preemption claims, which we never got to do. The exceptions simply gave the flavor of what this case is going to look like on remand, and then presumably a different appeal. And it bears noting that this goes both ways. In the Green case, it was the government that was trying to raise a new argument or a new issue regarding the tax issue for successive tax years. In McLean, it was the taxpayer raising a different kind of constitutional challenge to the same tax for a different tax year.
Would it be fair to say that with the benefit of perfect hindsight, assuming that the Ninth Circuit is correct, this court never even should have decided a case based on ownership because the district court erred in dismissing the tribe's preemption challenge back in 2002?
Well, but it dismissed the tribe's preemption challenge in 2002, not on the merits.
But on the grounds of standing. But it seems to me that in the wake of the Ninth Circuit's 2013 decision, it shouldn't have done so.
Well, the problem was, I agree. I think it's a questionable decision. Neither side appealed in that case, but because of a ruling as to Calpine, which had intervened under the Tax Injunction Act, and as to the tribe based on standing, it never got to the merits. We believe that the taxation of this power plant on the Fort Mojave Indian Reservation has always been unlawful. The problem is how to get the right challenge before the right court. That was the right challenge, but before the wrong court. It
seems the right way to get it before the court was the first way, which was an action in district court, because now, assuming you go back to the tax court isn't bound by the Ninth Circuit.
It isn't. The Arizona courts look to Ninth Circuit decisions, but aren't. If the Arizona courts end up going, with all respect, if the Arizona courts end up disagreeing with the Ninth Circuit, then there's, I think, a cert-worthy issue being posed for resolution of what is ultimately an issue of federal law. But the federal court never got to the issue, neither did the state court in Calpine. In a sense, if Calpine wants to bring, if South Point wants to bring the challenge, it has to do it in state court because it would otherwise run into the Tax Injunction Act jurisdictional issue in federal court. So yes, the tribe could have been in one and the private taxpayer could have been in another. But I don't think there are any jurisdictional issues to raising preemption in this case.
You may want to turn your attention to the error correction statute.
Thank you, Your Honor. The tax court was incorrect in dismissing the error correction claims because it essentially spun them on the basis of issue preclusion, the same theory. That is, that because Calpine had upheld the tax, it couldn't have been an error to tax. Now, Calpine may have insulated any error as to ownership, but that's a different ground for error. That's a 3E under the statute, section 3EI error, where there's a mistake as to ownership. That's not the error here. Calpine could not have prevented an error or insulated an error that wasn't an issue in Calpine. This is a completely different question than was raised in Calpine and a completely different species of error under the Arizona error correction statute. Interestingly, the department does not contest the definitional question. That is, it doesn't say that the application of federal preemption doctrine would not be an error. It simply says it was an error here because there's no federal preemption. So that requires you to get to the merits of whether or not there's preemption.
Although there's been some discussion that it takes a certain amount of discretion and judgment to assess nuanced questions of federal preemption, and maybe that's not what the error correction statute was designed to address. A clerk at Department of Revenue can't really be expected to reach these issues.
Well, that's true only as to the specific legal description species of error. There is no requirement under a subsection A, incorrect, erroneous, or illegal tax rate. There's no qualification that that has to be objective without discretion, opinion, or judgment. And the Arizona Supreme Court has made clear, as has this court, that you have to look at each species of error, and if it doesn't have a qualification that it has to be objective, then that doesn't apply. Okay. So there isn't one for illegal tax rate. The department's only argument as to illegal tax rate species of error is that it wasn't illegal because preemption doesn't apply. So that means you have to decide the merits, and that preemption applies regardless of whether it's categorical preemption under Chehalis Reservation and the BIA regulations, which we contend it is, in which case there is no discretion or judgment. And even if the department's right, it's Bracker analysis is still ultimately a legal conclusion as to whether or not federal law preempts the taxation. It either does preempt or it doesn't preempt. An assessor cannot sit there and say, well, today, in my view, it doesn't. They're either right or they're wrong. It's not, you wouldn't review that determination for abuse of discretion. You'd review it de novo because it's a legal determination. And so, but again, each species of error stands on its own. We only have to show one of them. One of them clearly requires a determination on the merits, however discretionary or judgmental. That's the illegal tax rate. And Lyons, I think, establishes that when you're dealing with an exemption or a preemption and the rate should have been zero, you have a claim of error. And the department doesn't contest that. As to the specific legal restriction.
Is that really accurate, counsel? The rate would be zero? I mean, your argument is there's no rate at all.
Right, the rate would be zero, the effective tax rate. That application of any tax rate to this property.
I mean, is that really an error correction statute issue?
It was in Lyons, because Lyons dealt with whether or not the property was exempt because the house was going to be used as a parsonage and therefore primarily for religious purposes. So the rate would have been zero. And the department doesn't contend that. And the department dutifully takes a very broad view of what constitutes an error because the error correction statute cuts both ways. That is, the department uses it to reach back and capture unpaid taxes for prior years, and taxpayers use it in order to recover taxes improperly paid or excessively paid for prior years. So I think the teaching of Lyon is that if an exemption results in a lawful tax, an error, preemption does the same thing because both say it shouldn't have been taxed at all. That's the whole point. But again, the department hasn't challenged the illegal tax rate argument other than to say it wasn't illegal because preemption doesn't apply. It has never suggested that if preemption applies that somehow this is not an error. Unless the court has any other questions, I'd like to reserve the rest of my time for rebuttal.
Okay, thank you.
May it please the court, my name is Kenneth Love. I represent the Arizona Department of Revenue in Mojave County in this matter as the appellee. With me at council table today is Kimberly Seigan, who also co-authored the brief. The issue is whether or not it was appropriate for the tax court to apply issue preclusion to the question of the legality of the taxation that was at issue. Legality is a very broad term, and I think that we made a concerted effort in our brief to demonstrate to this court that the department wanted very much to tee up the question of preemption. It did so by interposing and serving interrogatories upon Calpine at the time.
But it never sought an affirmative judgment that preemption didn't exist and and you can search the Court of Appeals decision in vain for any discussion of preemption.
That is absolutely true, Your Honor. However, what it said was this. It said, to the extent that the motion for summary judgment or cross motion for summary judgment is granted to the extent that they seek a judgment that the personal property and improvements that are the subject of this action are legally subject to property taxation by the state of Arizona and or Mojave County. Now, I acknowledge that's a rather broad statement. However, this question of, and I think it was interesting because I think that Mr. Cooper kind of stole the language that I used. The department did all it could to tee up the question of federal preemption.
Well, it could have done more. Right?
Well,
it could have sought a declaratory judgment. It could have asked for a holdings. Merely sending out interrogatories doesn't really climb the mountain as high as it could have been climbed.
Well, it apparently was somewhat persuasive in the view of Judge Whitten, and I guess that you have to somewhat ask whether his particular notation it is a matter of impatience or a matter of application of law.
I don't think it matters to us at all. We owe Judge Whitten no deference on a question of law. This is de novo review, isn't it?
It certainly is, Your Honor, and let me point something out. Here's what he said. South Point is the successor in interest to Calpine as recognized in Calpine. It is therefore bound by the acts and omissions of Calpine. The issue in Calpine was the taxability of the improvements. Potential preemption by federal law was an argument that might have been made in opposition to the claim of taxability. Calpine had a full and fair opportunity to raise it, but for whatever reason did not.
That sounds like a good dissertation of claim preclusion.
Well,
but it doesn't sound like issue preclusion to me.
Well, I choose to differ with you, Your Honor, and I think that a reading of yes, I do, Your Honor.
Yeah.
So I appreciate your giving me the opportunity to do it. I think that the case involves comment E to the restatement of judgment, section 27, and I'll read you the commentary. And admittedly, these are not cases that occur all the time. However, the restatement commentary states this: it is true that it is sometimes difficult to determine whether an issue was actually litigated. Even if it was not litigated, the party's reasons for not litigating the prior action may be such that preclusion would be appropriate. Now,
I understand that
and I'll show you, well.
Give me a moment. There's some restatement language that always leaves a little bit of room for the unanticipated situation. But when you say they had the opportunity, or when Judge Whitten says they had the opportunity to litigate that issue, that sounds exactly like an element of claim preclusion under the restatement test. It does not sound anything like an element of issue preclusion under the restatement test. And so for I don't think that Judge Whitten inquired into the motives as your language suggests. I don't think we have any opportunity to inquire into the motives for not raising preemption. Isn't the real issue, well, let me just ask you flat out, is this case about preemption?
This case that we're dealing with presently is whether or not the court appropriately dismissed the cause of action or the causes of action,
fair enough. That's what this appeal is about. But when filed, was this case about federal preemption?
If I have to look back on it, I would say that those were claims that were made by the plaintiff, and we looked back at both. And I will let the court know it's not part of the record, and that you could take judicial notice of the fact that the preemption questions were raised by the department in the federal court action that ultimately was dismissed on the standing case. They were things that we tried to tee up.
I didn't see the record in the federal case. Did the department take the position that the tribe lacked standing, back then, or did the court dismiss sua sponte?
No, I believe the court took, I believe that the department took the position that the tribe lacked standing.
Okay, and so the department then didn't really seek a ruling on preemption at that point. In fact, the department did everything it could to prevent a ruling on preemption in that forum.
You're absolutely correct. It wasn't necessary once the standing issue was resolved. However, it was an anticipated argument. Again, you know, if the operative word is teed up, which is something that South Point has used, we certainly attempted to tee up the issue both in the federal court action and at the state court level.
I hope that there is no case that uses that term.
No, I don't believe so. It might involve golf courses and other forms of torts, perhaps. But
I think we try and stay away from such.
All right, I'll try to do that. But in terms of cases that this court might want to look to in terms of support for the restatement provision, there's an unpublished Arizona Bankruptcy Court case that uses that commentary. It also refers to Mantee v. Brown, 427 Bankruptcy 715, FTC versus Abeta, 387 Bankruptcy 846, AGP Grain Cooperative versus White, 315 Bankruptcy 741, and probably most definitively refers to a case called In Re Dine, I hope I'm saying it correctly, Host Inc. Versus Pignato, 86 Bankruptcy 318 out of the United States District Court for the District of New Hampshire. Now, those cases do discuss issue preclusion within the context of Comment E. And you know, admittedly, the issue preclusion or the failure on the part of a party to raise an issue, you know, may occur within the context of the right to avoid self-incrimination, or may involve a default. Those are some of the issues that get involved. You won't find this precise. You know, I will acknowledge I can't find a case on point with this one where there was an attempt to raise it. And years later, the tax court said, you know, the issue has been resolved because and makes reference to the fact that there was it was raised, it could have been raised, and it wasn't.
I guess I confess I'm a little surprised that the department is even taking this collateral estoppel road. I mean, if as a matter of law the tax is preempted, then the tax is illegal, correct?
I would agree with that statement.
Okay. And so if it is preempted, I would be surprised if the department would take the position that it wishes to collect an illegal tax. And if it were to do so in this case, then in similarly situated cases, it would behave differently. And I would be surprised that the department would want to take a position that certain people are subject to illegal taxes and others aren't. Why not just litigate the issue on its merits? You're not, the tax court isn't bound by the Ninth Circuit, as I've pointed out. I express no view on whether the tax is truly preempted. Why not just proceed to a litigation on the merits?
Well,
by taking this position, don't you create the risk of developing a checkerboard of results that aren't legally sustainable?
I imagine that risk is there, Your Honor. However, I think that the department is certainly able to discern and take positions with respect to things like collateral estoppel when it sees it. I mean, I think that you have to stand in the shoes of the department when you realize, and perhaps it could be a knee-jerk reaction on the part of the department, but we've been through, you know, this case started off in the federal district court, then was litigated in the tax court, then there was an error correction case that was litigated in the tax court, and I think that the position and the posture of the department was, enough already. You know, it's something that my mother might say, but
It's an understandable feeling.
and I think, and in fact, you know, that is in fact, you know, kind of the dimension that guides the field of res judicata, collateral estoppel, whatever you want to say, is that enough is enough is enough. And I believe that, you know, and I understand the court's concern about the creation of a so-called checkerboard effect on this. However, I think that the particular facts of this, as I've laid out in terms of litigation that began when I started representing the department some 13 years ago, and is still ongoing, is something that is cause for its concern. Now, to address the preemption question a little further, you know, I think that I do want to correct a misimpression that we're dealing with here. Preemption may or may not pertain to this case, but I think that you know, if we get to the preemption question, certainly the court has to determine whether the preemption pertains, how much of it pertains to this particular property, which is a component which is made up of both personal property and real property improvements. Now, the taxpayer, you know, I think perhaps somewhat glibly stated, well, you know, we don't really, you know, it doesn't matter greatly to us because the only thing you'd be taxing would be several computers and desks. We don't happen to see personal property in that same light.
Well, and you may actually be right, and to the extent that the ultimate merits of the case depend on classification of property and ownership of property, then you've got a collateral estoppel defense because you already won that case based on ownership, right? But
well,
or classification.
It's all owned. The question is whether it's real property improvements or whether it's personal property,
which I don't think has been litigated.
No, and I don't think it is either, which is one of the, which you know, coincidentally marks part of the difficulty in dealing with this case as an error correction matter. It is not a simple case. It is not as simple as saying we meant 14 feet and it was 140 feet. You know, there are many layers of complexity to this matter that we think on its face precludes, you know, going back to tax years 2010 and 2011 for error correction purposes. Certainly the question of preemption, if it gets dealt with on remand, is not going to be a simple topic either. I agree with you on that, Your Honor. But it certainly has more levels of complexity than need be taken with respect to error correction. And I might want to point out, as I think was evident, I think that the department took the view of, and what was presented to the department at the preliminary stages of the error correction proceeding was this error correction is premised upon a BIA regulation from 2013, and the department said, well, that's all fine and good, but this pertains to taxes and values that were as of January 1, 2009 and 2010.
We could speculate as to what happened if there's a remand, but as I pointed out, the Ninth Circuit at least believes that this preemption was plain on the nose of your face, as the nose on your face since 1973. Not everybody may feel that way, but that's what they said.
Well, and that preemption, again, to add the other layer of complexity, is with respect to real property improvements, not necessarily the personal property. So again, that layer of complexity exists with respect to error correction.
Counsel, in fairness to you, this is an issue that's been litigated by several federal courts. There hasn't been uniform agreement on it. And the error correction statute is meant to be a quick, abbreviated procedure to fix something that's just a very clear error in an assessment or a categorization of property. And maybe this isn't really a good fit within that scheme. Is that your argument?
That if you're asking me to swing at that one, my answer is yes. Is that it is not.
Did I tee it up for you?
Yes, you teed it up. You teed it up appropriately, Your Honor. And that's a position I believe that we took before the tax court, and that's a question I believe that has merit before this court in terms of a decision as to whether or not the error correction proceeding was appropriate.
But to the extent that there is a significant amount of real property at issue that could be subject to preemption, wouldn't the error correction statute sort of be a perfect way to allow the department gracefully to avoid doing something it knows to be illegal? I mean, it might not apply to the entire tax imposed, but I wouldn't think the department would want to take the position that illegal taxes are okay as long as they've been around long enough.
Well, I think that, again, it goes to the question of the preemptive effect of the BIA regulation, and I think Judge Gould is perfectly correct, is that the uncertainty in this area of preemption is as...
Well, I wouldn't necessarily read Judge Gould as making a statement or me as to what we actually might do here. I don't think it's safe to say that that's even been decided. But my question to you is based on the premise that we can ignore the BIA regulation, and that the issue of preemption, it stands on its own without the regulation. So in that case, assuming the regulation never come out, wouldn't the error correction statute still serve a useful purpose to the extent that it was ultimately determined that there were taxes illegally imposed on real property improvements? Again, I think that your premise is the Chehalis decision, which is post the valuation date. Well, it may be post the valuation dates, but it makes the point that it was not creating a new doctrine of law, that law has been around now for 43 years. And it is conceivable, I gather, given some developments in the 11th Circuit, that we may actually see a United States Supreme Court decision on this. So if that is the case, if the United States Supreme Court says, yep, we meant it in 1973 and it's been the law all along, why wouldn't the error correction statute be an appropriate vehicle for the correction of the imposition of an illegal tax?
Simply because it's a decision of a court, perhaps of final jurisdiction, final decision of a court other than that on the property, and that rubs against the error correction statute. There's an express provision there. And Your Honor,
if you had a United States Supreme Court case that decided this issue, you could probably use the error correction statute then, couldn't you? I mean, now it's maybe undecided, but I'm just guessing.
It seems at some point the department has to recognize that courts have some say in the matter.
I don't think that we would dispute that, okay, Your Honor. Thank you. But the fact of the matter is and my time is up, but just to briefly make the point, if indeed the issue of preemption was decided 40 years ago, it does raise the question, why strategically, and this is a word that again, that you heard from South Point, why strategically, if the issue were so soundly decided, strategically did they so decide that they wanted to sidestep that issue?
As I say, many may not see it quite as clearly as the Ninth Circuit, and the Arizona Tax Court isn't bound by the Ninth Circuit in cases to which it's not a party, so you raise a fair question.
All right. Any further questions? I see I'm out of time.
No, thank you.
Thank you.
May it please the Court, I just have a few comments. First, this case is all about preemption. Entirely. It's not about ownership. It's not about any other issues. The challenge in this action is based on federal preemption. Now, it doesn't matter if the department wanted a ruling in the original Calpine case or is weary of litigating the legality of taxation. The test under Cheney Building, the Arizona Supreme Court's test, may not be teed up, but it's submitted for determination. That's the Supreme Court's language. Regardless of what discovery they sent out, there was no federal preemption issue that was submitted for determination in Calpine. There was no federal preemption issue submitted for determination in the federal court action brought by the tribe and joined by Calpine because the department thwarted that on standing and jurisdictional grounds. That was its right. But these issues have persisted, and they need to be resolved on the merits in this case. Now, this notion of strategic decisions about bringing challenges, it's perfectly okay as long as it's about different tax years, because different tax years are different claims. It's interesting that we cited and discussed at length the Green case from the Second Circuit, McLean Western, the restatement example, and the department is mum about the restatement or the other cases applying the restatement in the context of successive challenges. You're allowed to say, we think we can win this on ownership, we don't want to get into a preemption battle, lose, and then say, okay, as to a tax year 10 years from now, we're going to make another run because the law has been clarified in a way that's favorable. That's perfectly legitimate, and they cite no case law rejecting it. Now, they cite a restatement provision now, which I don't believe they cited before, and a bunch of cases about how you could, I gather they're arguing you could look at the motives for not bringing it. But that's not Arizona law. Arizona law, this court's decision in Air Freight Express, the Arizona Supreme Court's decision in 4501 North Point say that under issue preclusion, as opposed to claim preclusion, the prior issue must have been actually litigated. There are no exceptions. There's no, well, you really should have litigated in the prior case. One cannot sit around and say, gee, we can't imagine why you didn't bring it 40 years ago when the BIA has issued what it says are clarifying regulations, and the Ninth Circuit has issued a decision that it says states what the law has always been. It's very clear why parties would want to bring that now, even though they didn't bring it before, and that's perfectly okay.
I have a question for you. Are the error correction statutes really designed for these government officials to resolve a complicated preemption issue? Is that what those procedures are for?
Absolutely. Because there are different species of error that are statutorily defined. And one was there an illegal, erroneous, or improper tax rate? That is not subject to a qualification for only if it's objectively wrong or if it doesn't require judgment, opinion, or discretion. And the Arizona courts have made clear that you don't import that kind of qualification where the statute doesn't provide it. So that's absolutely correct. There are a lot of thorny legal issues. But that's not what those qualifications are talking about. They're talking about, are you sitting around and saying, gee, was that valuation really incorrect? Well, the assessor has to go through some kind of economic analysis, and there are lots of discretionary calls you make, and a lot of calls you make about what evidence will come in on whether what the value should have been for the property. Here, the question is, what does federal law demand? That is a legal determination that's reviewed as a matter of law de novo. It's not a discretionary decision that's reviewed for abuse of discretion. The Ninth Circuit ruled that, in fact, categorically, without any kind of interest balancing, the federal statute, Section 465, bars state taxation regardless of ownership. That is a clear legal principle. One last note. The department may say, well, it's a timing issue because of the valuation years. In the tax case that's been filed over the 2014 tax year, they continue to assert issue and claim preclusion, even as to a tax year that's after the BIA regulations and Chehalis. The attempts to avoid the issue need to end. This needs to go back down. We need to get a final decision on federal preemption on the merits. Thank you, Your Honor.
Thank you, counsel. Your arguments have been very interesting. We will take this matter under advisement and issue a ruling in due course, and we are adjourned.